So people are wigged out over the SEC's recent foray into the ICO world. So I'm getting a lot of clients who are asking me, you know, can I do an offering and exclude the United States? And of course you can. And if you've noticed, obviously with a lot of cryptocurrency exchanges, many exchanges, many ICOs, many platforms for any sort of crypto exchange, a lot of times they exclude the US because they don't want to avail themselves or be subject to US law. And it's a big hit to take because obviously it's a massive market that you're effectively withdrawing from, but you don't have obviously the complex regulation. So the question becomes, if you're going to sell to only non-US citizens, what securities laws or what laws do you actually need to consider? And the main tenet is something called Regulation S. Now, Regulation D is your crowdfunding exemption, and that's where your accredited, non-accredited investor nomenclature all comes from. Regulation S applies to any offering that is made by any company outside the United States. So if you are doing an ICO, if you're an ICO company and you're located inside the United States, this would be a exemption where you wouldn't have to follow the rules of Regulation D, meaning you could sell to accredited, non-accredited. You wouldn't have to file a Form D. You wouldn't have to do any of that. But all the sales efforts and all the sales have to occur outside the United States. And what does that entail? That means that you can only solicit non-U.S. residents or citizens, right? So that means anybody outside the state, you can solicit them. You yourself can be a domestic corporation, but anybody you attempt to even solicit can't be within the United States, meaning you can't try to solicit a couple U.S. citizens, be unsuccessful, and then raise money from foreign sources and then claim the exemption of Regulation S. That can't happen at all. So it's not a matter of success, it's a matter of intent, and it's a matter of structure. And so you have to be very careful in terms of how you're soliciting. And a best practice would be basically to, especially if it's web-based and an ICO, is to make sure that no marketing runs within the United States. Make sure that there's no access to your website to U.S. citizens, and definitely don't even appear or create the presumption that you attempted to solicit any number of U.S. citizens, because it'll destroy the exemption that basically allows you to sell with impunity, in the sense that you don't have to worry about the standard rules of solicitation. You don't have to worry about the standard rules of again, accredited, non-accredited. Okay, and again, this only applies when you are doing an ICO, you're doing some sort of offering, which is decidedly a securities offering. So it also, if you're kind of in that middle ground on an ICO basis where you're unsure as to whether or not your token qualifies as a security, the Regulation S sort of gives you that backdrop where even if it were deemed to be a security, it's an exempt transaction, provided you keep the solicitation outside the United States. And if it's not a security, then it doesn't apply whatsoever, and you have nothing to really worry about. So that's Regulation S. Feel free to check me out, Tracy from TracyFirm.com. Thanks.